Welcome back to our channel, Just Immigration News. 7 paths to legal status for undocumented immigrants. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. For undocumented immigrants residing in the United States, life is fraught with uncertainty and heightened risk. Recent political developments, including threats of mass deportations, have intensified fear within immigrant communities. Being apprehended by immigration authorities can lead to removal from the country, often resulting in family separation, financial disruption, and increased immigration penalties. Unlike the comprehensive amnesty program enacted under President Reagan in 1986, contemporary U.S. immigration law does not provide a broad path to legalization. Nevertheless, a variety of statutory provisions, administrative programs, and humanitarian options offer potential avenues for certain undocumented individuals to obtain lawful status. While eligibility is highly specific, understanding these options is essential for those seeking long-term security in the United States. Defining undocumented immigrants. Throughout this discussion, the term undocumented refers to immigrants residing in the U.S. without lawful immigration status. This may result from unauthorized entry or from the expiration of a previously valid non-immigrant visa, such as a tourist, student, or work visa. Specifically, the term entered without inspection denotes individuals who cross the border without undergoing processing by a U.S. Customs and Border Protection officer. Although programs such as Deferred Action for Childhood Arrivals protect approximately 650,000 individuals who arrived as children, DACA does not confer lawful status. It is a temporary form of relief that grants limited work authorization and protection from deportation. Like other undocumented immigrants, DACA recipients require viable pathways to permanent residency and citizenship. The ultimate goal for undocumented immigrants is securing a long-term lawful status, typically leading to a green card and eventual naturalization. The following sections outline the primary avenues currently available. 1. Green card for immediate relatives after visa overstay. Immediate relatives of U.S. citizens, including spouses, unmarried children under 21, and parents may adjust their status even after overstaying a visa, provided certain conditions are met. Visa overstay and its implications. A visa overstay occurs when a non-citizen remains in the U.S. beyond the authorized period. Overstays generally trigger penalties such as reentry bars. However, immediate relatives of U.S. citizens are exempt from certain restrictions, allowing adjustment of status in the U.S. without returning abroad. Eligibility criteria. Lawful entry. The applicant must have entered the U.S. through inspection at a recognized port of entry. Immediate relative status. The applicant must be the spouse, unmarried child under 21, or parent of a U.S. citizen. Admissibility. The applicant must not be inadmissible due to criminal convictions or national security concerns. Application process. Eligible individuals submit Form I-485, Application to Register Permanent Residence or Adjust Status, Form I-130, Petition for Alien Relative, Form I-864, Affidavit of Support, and Form I-693, Medical Examination. Additional documentation proving the familial relationship, lawful entry, and admissibility is also required. Challenges. Unlawful entry, criminal history, or prior immigration violations can complicate or prevent adjustment. Consulting an experienced immigration attorney is strongly advised. 2. Provisional Unlawful Presence Waiver, I-601A. For those who entered unlawfully or overstayed a visa, the Provisional Unlawful Presence Waiver provides a mechanism to bypass the 3 or 10-year reentry bars triggered by unlawful presence. Eligibility. Applicants must be physically present in the U.S., have an approved immigrant visa petition, demonstrate that a U.S. citizen or lawful permanent resident spouse or parent would face extreme hardship if the waiver is denied, not have disqualifying criminal or immigration violations. This waiver, if approved, allows applicants to pursue consular processing abroad while minimizing family separation. 3. Adjustment of status under Section 245I of the Life Act. Section 245I permits certain individuals to adjust status within the U.S. despite unlawful entry if a qualifying petition or labor certification was filed on or before April 30, 2001. Applicants must pay a $1,000 penalty in addition to standard fees and demonstrate eligibility based on the petition. This provision allows many individuals sponsored by employers or family members to remain in the U.S. while completing the green card process. 4. Military parole in place. Military parole in place provides relief to undocumented immediate family members of U.S. military personnel. Eligible applicants receive temporary legal status, work authorization, and may apply for permanent residency without leaving the country, thereby avoiding re-entry bars. Applicants must submit Form I-131 and demonstrate the family relationship and potential hardship to the service member. 5. Asylum. Individuals fleeing persecution in their home country may apply for asylum. Eligibility requires demonstrating past persecution or a well-founded fear of future persecution based on race, religion, nationality, membership in a social group, or political opinion. Asylees gain legal residence, employment authorization, and can apply for a green card after 1 year. Family members may also be petitioned for reunification. 6. U visa for crime victims. The U visa offers protection for undocumented immigrants who are victims of qualifying crimes and cooperate with law enforcement. It provides temporary legal status, work authorization, and a pathway to permanent residency after 3 years. Certain family members may also obtain derivative U visas. 7. Green card through registry. Registry allows long-term residents to apply for lawful permanent residence if they have continuously resided in the U.S. since before January 1, 1972, demonstrate good moral character, and are admissible. Though the eligibility date is historically restrictive, advocacy efforts continue to expand access. Non-LPR cancellation of removal. Undocumented immigrants in removal proceedings may qualify for cancellation of removal if they have resided continuously in the U.S. for at least 10 years, demonstrate good moral character, and can show exceptional hardship to a qualifying relative. This relief is limited to 4,000 green cards annually and is only available to those facing deportation. Although navigating the U.S. immigration system is complex and fraught with challenges, multiple legal avenues exist for undocumented immigrants to secure lawful status. Immediate relatives, long-term residents, asylum seekers, crime victims, and family members of military personnel may all have potential pathways to a green card and eventual citizenship. While not every individual will qualify, understanding these options, seeking experienced legal guidance, and staying informed about legislative developments are essential strategies for those striving to achieve security and stability in the United States. That is all for today in this video. See you later. Till then, take care.